called someone to see why the slides are not. Yeah, okay. Next. Sorry. Yeah, uniform domain name dispute resolution policy. Oh, this is what I did. Okay. Now we move away. Yeah. Okay. Sorry for that glitch. So I think most of you, particularly the young students who have sort of grown in the world, which is more digital than what we had seen when I was growing up, know the importance of the domain names. But just to sort of put it in the perspective, every website that you see has this numeric numbers. And when the scientists were working on way back about almost like 30 years ago, when they were working on how would the web world would work, they obviously realized that these kind of numeric numbers would never work, because how can people remember these numbers? They have to have a name, and therefore the system was devised that these numeric numbers actually translate to the name that you give to your domain. So whether it is your own university name, or whether well-known names like the Tatas, the Reliance, everyone, they have a domain name. And the so to say that today, whenever anyone goes wherever, whether socially or in the business context, when you come back, you actually go on the Google search engine and try to find the website of the party. So that is how the importance of the domain names have become. Obviously, it helps the companies to build their business image, because when they go to their website, they see what kind of activities are present, what sort of products and services are being provided. And at the same time, you would see many of the companies now on their websites, which obviously is reachable through a domain name, would also put their the governance, the ESG or the CSR activities as well. So it helps to build that direct kind of image for the business. Of course, and the oft-repeated, tagline that data is the new oil also comes into the play when it comes to your own website. The traffic that you generate and what comes to your website through your domain name would obviously mean that you connect with the customers. You can also capture that data. You would have seen nowadays that everyone, has to give a warning that there are cookies on the website. Would you accept them? Because what they're doing is actually they're capturing your the web address, your likings, what you access, and they're trying to build that what is it that within our website people are visiting, what are they liking, how much time do they stay on a particular page, etc. So it's a completely different topic that how much of it is sort of legal, and what is illegal, where can the boundaries be drawn, where does the privacy issues comes into play. But anyway, today we are on the domain name. So this is just in a nutshell the importance of the domain names. So there's an organization called ICANN, which is the one which devised the domain name system of the world. And then there are obviously two kind of domain names we're talking about. One are the generic top level domain names, which is called the GTLDs. These are the kind of famous one, the .com, the .info, and the recent one being the .name, .biz, etc. So these are what we call as the generic top level domain names. And then there are, each of the countries have their own, top level domain names, what we call as the country specific CCTLDs. So for example, for India, it is .in. So under the ICANN regulation, the generic top level domain names are governed, any disputes relating to those are governed through the UDRP policy, whereas it is left to each country to devise its own dispute resolution policy when it comes to the country level top domains. Many countries have actually said that, look, we will follow the UDRP. For us in India, we have our own policy, which is the INDRP policy or .in dispute resolution policy. Which is modeled on the lines of UDRP. It has got the same ingredient that you have to prove. And but there are a few differences, and we will see when we go further. And the decisions that are given under the INDRP are treated as the arbitral awards. So essentially, if you want to file an appeal against an order of the given in the INDRP, then it will go under the Arbitration Act. So the power of the court to interfere with whatever the arbitral award, as you would know, is very limited, and the courts do not want to interfere. The classic example these days, if you are following the news, would be the dispute between the Amazon and the Future Group, where they are trying to sell it to the Reliance, and they have an order from the Singapore Arbitration Center, and they have Future is trying desperately to get that order set aside, and but the right up till the Supreme Court, they've been told that, look, go ahead, we can't interfere with the arbitration award. Incidentally, I was arguing the matter day before against an arbitration award, and this is exactly what the judge told me. And I was trying to convince the judge that, look, the interpretation of what is deceptively similar is against the principles laid down by the Supreme Court in this particular matter. But the court sort of sent me back and said that, look, the arbitration award, I have a very limited power to interfere with anything that the arbitrator would decide, because it is, if even if it is wrong and is subject to another interpretation, I cannot interfere into an award given by the arbitrator. So that's the difference between the INDRP and UDRP to a certain extent, because the UDRP makes it very clear also that you can if you are not satisfied with the order of the UDRP panelists, they call it, they don't call them as arbitrator. So there is a panel that is appointed to sort of decide or adjudicate on a domain dispute that you file before the WIPO. And those panelists' decision can be challenged in any court of law. But there is again, which court can you go would be decided based on what kind of forum that you have chosen in terms of jurisdiction when you draft that complaint before the UDRP. Right. So, what kind of disputes are covered by the UDRP? These are similar to what is covered under the INDRP. Um, so you can, it is essentially when you see that someone has obtained a domain registration which is similar to your domain name. I think the challenge, and I will come back to that in the little later, is the major challenge in the domain names are because of the typo squatting, what we call it. So, for example, you can write the word Bata by just adding, replacing the word Bata by with an A with an E, and still say that beta, or something similar, which would sound very same and can be confusing for the people, for the general public, is something which we see more often than not happening, and that is the reason why we see so many UDRP complaints being filed everywhere. Uh, but the best thing about the, why you would go in for a UDRP is that sitting anywhere in the world and wherever the domain name may be registered, you could file a complaint online through, there are obviously accredited centers of where ICANN has appointed WIPO as one of the accredited centers to administer the Uniform Dispute Resolution Policy, or the UDRP as we say it. And it's quite popular, and that is where you can file a complaint online. It's the whole process is very seamless. It's, within the 60 days they decide the complaint. There is a fees they charge, which is currently 1,500 US dollars for one complaint. You can also combine more than one domain name in the same complaint if the registrant is the same, who has applied for, and many more variations of the domain name, or if he has used the different top level domain name. So for example, if someone was to use bata.com, and then he also applies for bata.net, and if the registrant is the same, then you can file a single domain name complaint against both of them, and that will be, administered by the WIPO. Sorry, I'm having this difficulty in moving my. So there are, you know, 5 stages in the administrative procedure. As I mentioned that, there are ICANN accredited dispute resolution service provider. WIPO is one of them, which is very popular. In the US, they have the National Arbitration Center, which is equally popular among the US, based this thing, because they find it easier, to file complaints where they are based. You can choose whether the panelist, what we call under the INDRP as arbitrator, whether the complaint has to be decided between one panelist, or you want more than one panelist to be appointed. Generally, either one or three of them can be appointed, and there is more fees to be paid. 90% of the complaints are actually decided by one panelist, but in some cases the other party may ask for a panelist, another panelist to be appointed, and there is a higher fees to be paid. And as I mentioned, within 60 days, they should be, decided. The complaint is decided. There is no like a civil procedure. We have the cross examination, or any such procedure is not followed. Whatever documents you submit, it will be decided based on that. The panelist that is appointed can actually ask for clarification. So if he goes through the complaint and he sees that there is something missing, or he's not able to understand the argument being made, or if he sees that there are any gaps in the issues that are being pleaded, then he can ask for a clarification and issue what we call as the interrogatories to the other side, and say that, look, I mean, I want clarification on those. And in case no appeal is filed post 30 days after the order, then the UDRP, the domain name will, whatever you have prayed for, either for the cancellation of the domain or transfer of the domain, it will be granted. Most companies, from the practical point of view, would like to ask for the transfer of the domain name, although it becomes another burden for them to keep renewing it. But once they see that this is a commonly now copied, domain name, then they would like to have generally make a request for transfer of the domain name, because cancellation of a domain name would mean that it would fall into the public space and anyone else can again register it. So, as I mentioned, some of it I covered. So, more informal procedure, than the litigation. The decision is being made by the experts. It's got the international scope, so you don't have to travel to a particular country to get the domain dispute resolution. You can invoke it sitting in wherever your offices are, and it is typically more faster and cheaper. If you imagine that, someone in, let's say, Costa Rica, or anywhere else would have copied your domain name, or there are so many Indians living in the US, and that sometimes there are disputes relating to, like, for example, the Maruti car had this dispute on somebody had copied Maruti domain name, and they had there was that went to UDRP, came back to the High Court. The plea taken was that Maruti is the name of the god, and I'm Indian, and I worship the Maruti, the Hanumanji, which is the Maruti god, and another name for the. So there is a legitimate use, etc. But without going into the facts of the dispute, what you would see, appreciate is that sitting in India, they otherwise, if they had to go to the US, it would be much, much more expensive to fight that dispute out. And half of the time, people would not actually, do it. So, I touched upon this as well. So I think the challenge, and some of it is my thoughts as well, based on the experiences that I have. The challenge for brand owners against domain name system, and I won't say just the squatters, but the system overall, emanates from the fact that today you and me, without having to have any documents, as a natural person, can go and register a domain name through any of the accredited registrar like GoDaddy, or anyone, and there are no questions asked. There is nothing in terms of, like, what we understand as your customer type of document, that what's your PAN number or what's your address, give me a proof. They just take an undertaking from you that whatever information you're providing in terms of your address and everything is correct, whatever your name you're providing. So I could actually be filing a domain name which would be in the name of, let's say, Donald Trump, and I could just become a Donald Trump, and nobody would ask me any questions, and you could do that. So I find that very distressing, because for a lot of clients it becomes very difficult then to track back, and to add to that, the this proxy and services and privacy protected services, which have which are also legitimate because ICANN has authorized them, come into play as well, whereby people can hide their identity. They can simply say that the name of the registrant would appear as privacy protected. So it becomes another layer when you are filing an action, that look, okay, you request for that information, and if you request for information, generally they would not give you. There are terms and conditions. While and this has all been flagged, ICANN holds every year. They have their own symposiums, and brand owners lobby them to say that please change these rules. These are not helping. Many organizations have passed the resolutions against this. That this is actually proving to be quite difficult. And with the coming in of the GDPR, I hope people understand global, the privacy rules, which have come in, which is affected in the Europe, which is considered as the gold standard for the privacy issues. Now, for the natural person, as opposed to the businesses, the every domain registrar is actually required to hide their identity, so that, and which means that when you are searching for the domain names being copied by a third party, and you are trying to determine who has copied it and trying to develop a pattern of who the person is, it becomes all the more difficult. You have to spend more money. There's an extra layer that is being added, and if you want to go and take a quick court action, and in the real world, the businesses gets really edgy when they want to take an action, and they just don't care how things work. They just want you to go ahead and get an order for them, stop this activity, it's harming us, and I think in some cases it actually becomes very important, particularly with the technology. There are so many job scams being propagated everywhere. People set up the website. As I mentioned, the websites would have a typo spot. They would say, like, geo. They'll make it as an A, but people won't notice it. They would see it as a geo.com, and they will offer jobs. They will have job posting, and people will visit them. And so typically in that scenario, every business wants that, look, shut down that website, and when they go and look at the whois details, so if you want to search the name of who the domain owner is, you will have to carry out a whois search, And during that who is search, you will find that who is the registrant, what his address is, and after the coming of the GDPR, most of the times that information is redacted or it is privacy protected, and as a result, it becomes more difficult to take action. There's an extra layer of information that is added. So I just thought I'll share with you some of the cases as well. So this was a dispute filed by Google under the INDRP, as I mentioned, .in dispute resolution policy, against someone who had set up a website called googly.in. And the arbitrator in this case, ruled in favor of Google, and recognizing that the word Google and googly in the internet world and the way they had represented the word googly was very similar. But after the decision, they challenged the award. One Mr. Khatri, who was the had applied for that domain name, he challenged the award to the High Court. And in this case as well, the High Court said that there is nothing wrong in this, and judge in a very cheeky way, if you read that last sentence, it says Mr. Khatri stands bold by his own googly. So he actually was arguing that, look, okay, I mean, googly is a term on cricket, everybody would use it, there would be no confusion, etc. But then it went against him. One of the leading cases on the domain name is also a Supreme Court decision. Is the Supreme Court decision in Satyam Infoway versus Ciphy. So this is popularly called as the Ciphy decision. Again, I'm not going to go into the details of this from the point of view of reading this thing, because we have paucity of time and I want to cover another topic. But the crux that came in this case, and which is now become the sort of a rule for all future domain name cases, is that the trademarks, the domain names are akin to trademarks. They perform the same function as a trademark, and therefore they should be protected in the similar manner as you would protect a trademark. So in this case, the argument taken by the respondent was that I am not. So his trademark, as you would see, his domain names were Ciphy Real Estate and Ciphy Mall, whereas the Satyam Infoway, the domain names were Ciphy.net and Ciphy.net. So they were the same domain names with two different GTLDs by them. So the main argument was that there cannot be an intellectual property in domain names because they are only an address on the internet. So remember my first slide, that these are actually numeric addresses for which the technology has made it possible that we can actually now put our word to it. But they actually, from the technical point of view, are an address to reach to that particular website. So his argument was that there is nothing but this thing. But the court said that, look, um, we don't agree with that, because ultimately what the consumer see is a name, a domain name, and that is how he or she accesses a website. Therefore, the principles that are followed in all trademark cases, the concept of passing off that comes into play in the trademark cases, would also be applicable here. And so the matter went up to the Supreme Court. At the District Court, Bangalore ruled in favor of the Satyam, but the High Court stayed the order and said that we don't agree with that. And then the matter went up to the Supreme Court, and where it was decided in favor of Satyam. So there are these principles which have been laid down in this case. These are very important for you. If you get the opportunity, I would strongly recommend that you should read this judgment to get a good clarity on what the interlink between the trademarks and the domain names. That this is a judgment which is kind of Bible, which would be quoted in every case that is filed in the domain name world. And so, last but not the least, this was again a case filed by Arun Jaitley himself when he was alive. God bless his soul. It was, someone who had copied the and registered arunjaitley.com. And again, the principle in this case was what was reiterated in the Ciphy case as well, that the domain name is not the same, is, has gone through a change, and the people use their domain names not just for the company name but for themselves personally as well. It does not remain an address no longer. It performs the function of a trademark. And the prospective customers, and I gave this example that typically when you would go out, you see any sort of name board even when you are driving, or you go to a, let's say, an exhibition, and you find something interesting and you note down, and you have a vague memory of what the brand was being used by that person, you actually come back and search for the website. So that is how important the domain names are, and the court has recognized it in this particular listing. So that was my first part of the domain name. We could take few minutes now, or we can do later the questions on this part. How would you like it to be, Dr. Satish? Should we get the questions in the end, or you want it to be now on the domain names
Sir, I think questions, we could take questions in the end, or if the students, they have anything to ask for, so they may ask right
in the
now.
chat box?
The students, you wish to ask anything in the middle of the presentation or in the end? So could we go ahead? Excuse me. Excuse me. Could we go ahead? Sir, I think we should go ahead.
Okay. So the second aspect of the presentation was that how the technology interfaces with the trademark, and what is it that is changing. So I call it that the branding in the digital world. Domain name is a part of that digital world, but there are other things which are happening. And I think the most bigger change that has happened in the digital world is the brought by pandemic. Um, so this is not no-brainer. Each one of you would agree that with all this care that we all had during the COVID-19 period, right from the March 2020, we all were less and lesser going out to places where we would have contact with other people, and digital world was our only source for sourcing any kind of goods and services. But in any case, the ecosystem, as I see, for the digital world has been set up because of what I call it cheap data plans, or a geo phenomenon, whereby you can get at a very small cost a large amount of data, and as a result, many people are all the time on the phones. Not that I am saying anything, but you guys got to think about it. Again, because the banks, or in the Paytm sort of things, the banking apps, all of these, has also made the digital world quite popular. Keep that in mind, that anyone who is, operating these apps, or is, operating either a digital wallet, or having an app created or a website created, is always using a name attached to it. So trademarks are everywhere, wherever in the digital world you go. The digital world also became popular because of Amazons and Flipkarts of this world, where there were always attractive offers. People were buying, and at half of the cost, of whatever. Online education became quite popular during this time. So all of this phenomenon has helped, or sort of created a parallel market of counterfeit. And again, the digital world, or the technology to a certain extent, and this is a big problem for every brand owners. 10 years back, when the luxury goods, when the digital world was growing, they actually completely ignored the digital world. And they never thought that, someone would go and buy a Montblanc pen, or a Burberry handbag, online. The situation is completely changed now. Each one of them is actually creating their own web stores or creating that digital experience because they've realized that people actually want to buy online, even the luxury goods as well. And in fact, the margin among in the luxury goods has actually has kind of created a market where most of they say, one of the surveys says that 25% of the goods, fake luxury goods, are sold online only, particularly when it comes to, and this is a survey for India. We are also seeing another parallel kind of an economy in the digital world being created, what we now call as social commerce, where you don't need to actually, create an e-commerce site or don't need to go to the e-commerce platforms to sell your products, but you actually create an Instagram page or a Facebook page and, link it up to your, UPI or any other QRS codes and, or to a wallet and can sell your goods. So this is where the changes in the digital world is happening, and the trademarks are at the center of it, because there are people who are finding this opportunity because of the anonymity of the internet, that they can actually go and sell the goods, um, counterfeit goods online. Now, we all know that the platforms like Amazon, Flipkarts, and the Snapdeal or Shopclues, or some of the others like Paytm Mall, etc., are very popular. And if the counterfeit goods are available there, why can't we just go and take action against them? We can't take action against them because of the legal provision pertaining to e-commerce portals, which say that an e-commerce portal is an intermediary. So, as per the Information Technology Act's definition of intermediary, covers the search engines, the online payment sites. So they can simply come to the court and say that, look, I am not liable for sale of, the counterfeit goods, so long as they are able to show that they are, carrying out the due diligence in terms of enrolling the sellers. So they essentially, and have, someone like Amazon or Flipkart, when found selling counterfeit goods, would simply come and argue that, look, I am only providing the space, as you would provide a space in the shopping mall. If a person opens a shop and there and at that shop is offering the counterfeit goods, I am not liable. So there are specific, what we call as the safe harbor provisions provided under the Information Technology Act, what we call as, which is contained in section 79 of the Information Technology Act. So I'll keep talking because I don't know why this is not moving. So Section 79 of the Information Technology Act was specifically carved out because it was felt that if the e-commerce platforms will never be able to operate freely unless they are, given this uh, sort of safe harbor, as it is, the word safe harbor is not used in information technology. It has come out more like from a US decisions where they started calling that, these intermediaries which are not playing an active role in any transaction should be protected. Otherwise, it'll be very difficult for them to operate. So the section 79 of our act, so long as the only thing that our intermediary has to do is to, as I mentioned, has to provide that he's observing the due diligence as per the guidelines that have been provided. And the information that it is storing is a temporary, temporarily being stored there. Uh, Exceptions to the section. So what you would see is why I'm spending so much time on this is because it's a major issue and today, and there is a lot of tension between the trademark owners and the platform operators. And this is not just the Amazon and the Flipkart. It also goes to the Facebook. It goes to the Instagram, where each one of them, whether it's big or small, each one of them claim an intermediate safe harbor provision and say that we are intermediaries, we are not liable, therefore we shouldn't be held liable for any kind of piracy or counterfeit goods, or any such activity that is happening on our platforms. And obviously, if I am on the brand owner side, I am saying that, look, why should I be made to run after each and every person who's selling the counterfeit goods? This is the space that you have provided, and it should be you who should be equally liable if there are counterfeit goods being sold. Now, unfortunately, they, once you give them the notice, what happens is that they say, okay, provide me the URL and I will remove it. Once you remove it, then once they remove it, the parties actually create, come back with a different name, and the goods come back again, or there are so many traders, someone or the other keeps uploading it. Things have changed a little bit with the coming of the GST regulations, because the GST, if you don't have a GST registration, you cannot sell goods online. Therefore, every person has to have a GST registration to sell goods on Amazon or Flipkart, and that is where it is actually helping to a certain extent. But you can imagine this, that look, for example, a recent example of yesterday was there was a some pharmaceutical client who found that his goods, which could also be sold online, in the sense that they were targeted towards hair growth, tonics and things like those. Although a pharmaceutical preparation, it contained really the drug and it is a scheduled drug, but was being sold online. And when it went back to these, Amazon and Flipkarts of this world to ask for the information about the trader, they said that, look, we are bound by our confidentiality clause with the traders, and we will not provide you that unless you go to the court and get me a court order. And what and this similar thought process goes on into the mind of the brand owner all the time, because once you see someone selling the goods online, he can either send a notice to the Flipkart or Amazon of this world and tell him that, look, okay, bring down these goods. If he wants more information about them, he has to go to the court and get a court order. In case the goods are not identical, they are infringing. These websites, e-commerce platforms can also say no to them and say that, look, I don't know. I cannot determine whether what is infringement, because this is not a counterfeit good. This is not a piracy, and I will, get me a court order. This is mandated by a case which is called, if you want to look it up, you search by the keyword Shreya single judgment of the Supreme Court, which was actually based on the on a different issue of Section 66 being whether violative of the Constitution or not. And later on, it also turned its attention towards whether how much is the liability of the e-commerce platform. And the Supreme Court ruling in this case says that, look, e-commerce platforms have the sort of discretion to say no to any request for bringing down the any goods or services being sold on their platform if they are in doubt and ask for a court order, and the brand owners obviously don't like it. And this case you have it in front of you is popularly called as Myspace case. Although it was a copyright dispute where on the Myspace, which is you could this is like 10 years back, so this is kind of you could say mishmash of what we have today, an Instagram and a YouTube, you could say, or an Instagram and a Facebook kind of a situation. Myspace was very popular at that time. It also hit, I think, almost like 1 billion users, but it is no longer that popular. Anyway, this case was about T series, this thing being uploaded on the songs being uploaded on their website by the users, and the T-Series did not like it, and they said, look, you are liable for it. So this was the first ever case where intermediary liability came into play. And all what I have just explained to you, the court came to the same conclusion. While the T-Series wanted a blanket order to say that you will never upload anything, The court said, no, nothing doing. We cannot pass such a blanket order. You will have to give him the URL. You can't. T-Series says, I will provide them my entire library of songs so that they should monitor this space and bring it down. And the court said, no, they don't. They're not required to monitor it. If you are concerned with any kind of a copyright infringement here, then you need to give them the URLs and they will take it down. So you can see at the moment, the first round in some sense is in favor of the e-commerce platforms. I don't blame them because at the same time, it cuts across the freedom of speech and expression as well. Because if everything, anybody notifies these platforms and they will have to bring it down, then there are many cases where newspaper reports or some other people would make videos or put it on somewhere where they are actually discussing about let's say a well-known businessman, and they will be slapped, and there are defamation notices being sent to the person who's uploaded it, but would make the platform liable. And that is not the situation, which is a very good situation to have in terms of the free exchange of information. Uh, so as you would see in this case, while the single judge ruled that the MySpace action constituted an infringement under the Copyright Act, but the division bench set aside that and took the view that MySpace had no role to play in uploading of the infringing materials. They had taken adequate measures to weed out the infringing materials, and actual knowledge on the part of MySpace could not be proved. There are some thoughts, this is obviously, it goes back a little far. So there is, this part of the jurisprudence is still developing. Now, this was the case brought against Shopclues by Skull Candy, and there were actually many other people who had brought it as well against the Shopclues for selling the counterfeit, goods in them. The question in this case that came, and which was quite interesting, was that the single judge of the Delhi High Court actually made out a list of 26 action items and said that, look, for example, without making myself as a, someone who is passing a judgment here, this is purely what the court said. If you look at the Amazon, it collects the money from you. It actually packs the goods in the boxes that they have. It actually orders. It monitors that it reaches you in time. So the court calls out 26 such things which these platforms were actually providing, and it said that if this is all what they are doing, can it in the real sense be said that they are an intermediary and they are simply just providing the space? They are actually doing more than what they are, more than providing the space. And we thought this will change the jurisprudence altogether, but this went into an appeal to the division bench of the Delhi High Court, and the order was stayed there. The orders, as I mentioned here, so they said that, as I said, they culled out 26 tasks. Quite interesting decision if you want to read, and the court came that if this is what it is, then it will render the intermediary as someone playing more active role than just being an intermediary. I put this case here also because of the observation of the court in this case, which was actually brought by Reliance against Quicker. Quicker, as you know, is kind of a classified advertisement platform where they also post job posts these days. And what they found was, the lots of employment job opportunities were being advertised on the Quicker platform, and Reliance was under a lot of distress from the number of calls and the emails that they were receiving, and they wanted to do something about it. And so, typically, as it happens in the first instance, you go back to the platform and say, okay, here are the 20 URLs, can you remove it? The moment you send that, by the time they take action, you go back and you see 20 more, and you send it again. So they got fed up and they said, look, you block everything. They said, sorry, we can't do anything. So they went to the court. So the defense was that, look, we don't actually do anything ourselves. This is what most of the time the platform would say. We have an algorithm written, we have forms. You fill that form. We take undertaking from anyone, posting anything, whether it is goods or whether it is job post or anything, where we say you do not infringe anyone's right. You declare that you have the rights in doing what you're doing, and various other kind of disclaimers and undertakings and warranties that they take from them before they can actually upload it. People just tick the box and they say, okay, let's just upload it. What's there? So when they came there, they said to the single judge, this matter is again pending, and you if you read the remarks of the court, which I have judge, which are in the italics, and the judge said that, look, so what if you've written an algorithm? You don't run the web portal for charity, but you earn income from it. And since the system is auto generated, the defendant has, and they said no mechanism. This cannot be accepted, the judge says. Whether it needs a policy change, whether it needs something that you will have to do at your end to better monitor it, then you will have to do it, because if this is the way it will be, then every job seeker will be deceived by these kind of postings, and everybody and they would have made money. I mean, we have handled many such actions where people have put the job posts and created the website. There was a case that we handled for one of the US based hotel company, where someone had created a domain name. Again, as I mentioned, anybody can create a domain name. So the hotel name with canada.com was available. They created it. They would actually advertise it on the various such portals like Naukri, Quicker, etc. And they would purposely advertise for small jobs like plumbers, electricians. And so those, people would see that job post and they would be excited. They would apply for it. Then these people will be contacted by phones, and and ultimately they would be asked to pay some money to process their application. So they had collected a lot of money like that. When we investigated it, we found that the account was opened somewhere in Guwahati. It was an old lady who's was created as a front up, who she did not know anything about it. Through her KYC, an account was opened and the money was being withdrawn in Bangalore and Delhi through that account. So welcome to the digital world. This is how it happens. The trademarks, as I said, are the technology interface. While it has made our life very convenient, it has again, at the same time, it has given us a lot of challenges. So that was the end of my, I think, presentation. This is just about us, and that's it. I mean, there are many other issues in the technology interface that that we see, whether it is related to meta tags, whether it is a recent judgment of the Delhi High Court has come out on Google AdWords program. So there are many issues which we see are happening in the digital world, and there could be one complete session that could be devoted to the issues. So, but with the positive time, I would stop here and make myself available for any questions that you may have.
Students, I think you all have, I have unmuted you all. So if you wish to ask anything, you could do it yourself, or you could type your questions in the chat box. Ajay, yes, beta. If you have any questions, you may ask. Am I audible to you all?
Yes, ma'am, you're audible.
Yes, yes. Nalinaksha, could you please invite the questions in the chat box, or they can ask because they can unmute themselves.
Yes, ma'am, sure.
Are there any questions or should we sign off the session? Students, are there any queries or observations or should we sign off the session?
Ma'am, I think sir was very clear in everything that he explained.
Yes.
So I don't think there are a lot of queries from our end.
Okay. All right. Thank you so much, sir. And it was indeed such a clear session that everybody is like they are writing in the chat box that the session was quite apparent and clear and they do not have any further query regarding the session. Thank you so much.
Okay.
Thank
That's
you,
great.
sir, for your
Thank you for
valuable
having
time,
me.
and we would love to hear you again in another session if we end up finalizing one. Very informative session, sir. Thank you so much for your time. Thank you, sir.
Thank you. Thank you very much. I enjoyed it as well. Thank you.
Thank you, sir.
All the very best to everyone. Bye.